The Zina Ordinance, enacted in Pakistan in 1979, is a significant piece of legislation that has sparked considerable debate and controversy. It aims to codify offences related to extramarital sexual relations and adultery, drawing from interpretations of Islamic law. The ordinance has wide-ranging implications impacting legal proceedings, social norms, and the lives of individuals accused and convicted under its provisions. Understanding the key sections of this ordinance is crucial for comprehending its scope and impact on Pakistani society. The Zina Ordinance, officially titled the Offence of Zina, Enforcement of Hudud Ordinance 1979, announces its purpose directly in its name. The term hudud refers to punishments considered mandatory in Islamic law. This section clarifies the ordinance's geographical reach, applying to the entirety of Pakistan. It also establishes the date from which the ordinance came into effect, marking a turning point in the country's legal landscape. Section 2 of the Zina Ordinance lays the groundwork by defining crucial terms used throughout the legislation. Words like zina, had, qazf, and others are given specific legal meanings. For example, zina is defined as sexual intercourse between a man and a woman who are not validly married to each other. Understanding these definitions is essential for accurately interpreting the ordinance's subsequent sections and their implications. These definitions set the stage for how the law will be applied and interpreted in specific cases. The Act of Zina exploring Section 4. Section 4 delves into the heart of the ordinance, outlining the Act of Zina itself. It states that any man and woman who voluntarily engage in sexual intercourse outside the bounds of a valid marriage commit the offence of zina. This section emphasizes the element of consent, specifying that the act must be voluntary for it to constitute zina under this ordinance. The inclusion of the word voluntary aims to differentiate consensual acts from those that are non-consensual or coerced. Had punishment for zina. Delving into Section 5. Section 5 outlines the punishments prescribed for those convicted of zina liable to had. This category of zina carries specific requirements for proof, often demanding a high burden of evidence. Punishments under this section, known as had punishments, are severe and fixed in nature. For those found guilty, the penalties can include flogging and even death by stoning, reflecting the strict interpretations of Islamic law that underpin this section. Exemptions and exceptions. Unpacking Sections 5A, 7, 8, and 9. Sections 5A, 7, 8, and 9 introduce nuances and exceptions to the application of the Zina Ordinance. Section 5A, for instance, prevents cases initially registered under other laws from being converted into Zina cases, aiming to prevent manipulation of the legal system. Section 7 addresses cases involving minors, stipulating different punishments for individuals who have not reached the age of majority. Section 8 delves into the complex issue of proof in cases of zina liable to had, setting stringent evidentiary standards. Finally, Section 9 outlines specific situations where the had punishment shall not be enforced, recognizing potential mitigating circumstances.